Yeah. We're live.
We're live.
Okay, and we are on time, and we have quorum. Set my cell phone to vibrate. And I recommend people in the audience do that as well. Oops. So I recommend everyone turn their cell phone off or vibrate or something. You don't want me to be staring at you when your phone starts ringing. Good morning, everyone. My name is Jason Marks. I'm the Chair of Board of Ethics and Campaign Practices. We're calling to order our meeting for Wednesday, September 10th, 2025. We have a quorum present. Let the record reflect that all the members of the board are present at the start of the meeting other than Ms. Selvin. And with that, we will dive into our agenda. Item 2 is review and approval of the September 10th, 2025. Are there any comments or issues with the agenda or a motion to approve as presented?
I will move to approve the agenda.
It's been moved by member Caffrey. Is there a second?
Second.
Member Green has seconded. All in favor, signify by saying aye.
Aye.
Opposed, nay. Motion carries. Item 3 is review and approval. Say August 20th. Anyone need more time to look at them? Not hearing that. Anyone have any proposed changes? Hearing none. Is there a motion? Mr. Kelly.
Did you say Wednesday the 20th or Wednesday the 13th?
I said Wednesday the 20th because that's what's in what I'm reading here.
I thought we were talking about the minutes. I may be mistaken.
You know, we are talking about the minutes. We've got Mr. Rocha. Is this? We did in fact meet on the 20th. That was a special meeting.
Yes.
It was a special meeting, Mr. Kelly. We had that issue with the Leva campaign where we met on the 13th, and they asked to come back with a semi-settlement the week later in the special meetings. That's why it's the 20th. Is there a motion to approve the minutes from August 20th?
I move to approve the minutes from September 20th. Sorry, August 20th.
August 20th.
Oh,
Okay,
sorry. 20th.
I don't rely on my fingers read. Is there a second?
Second.
Second, Mr. Kelly. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? Hearing none, the motion is adopted. Minutes are approved. Next, we have item 4 is the advisory opinion AB 05-2025. And we'll have Mr. Jackson present a draft on that and explain the request and what his recommendation is.
Thank you, Mr. Chair and members of the board. So the requester here is one of the mayoral candidates, Alexander Obias. And Mr. Obias seeks clarification on 2 issues: whether the election code or other campaign regulations allow a privately financed candidate to accept contributions from an individual who prefers not to disclose a residential address for any number of reasons. Maybe they have concerns about their personal security. Perhaps they are military serving overseas and want to use their military mailing address, or they're traveling internationally and just simply don't. And what it says in the request is that they prefer to use a local post office address. And then the second question is whether a privately financed candidate can accept contributions from either an individual whose employer uses a PO box or a business that only uses a PO box due to the nature of its work. And the requester provides 7 examples. One of them is an out-of-state prosecutor who expressed concerns about that disclosure of the residential address could compromise the contributor's safety. Then a local criminal defense attorney, it doesn't say whether that's a private criminal defense attorney or a LOPD, but has the same concern and suggested 2 state law exemptions that might apply. Then there's a retired individual who's traveling internationally, and here it says does not have a residential address, rather than would prefer to use a local PO box. A JAG attorney who's overseas would prefer to use the military mailing address. And then 3 contributors who are employed by entities that use a PO box rather than a street address. What the draft opinion proposes to offer as guidance is that a residential address need be disclosed only for contributors who are individuals, not non-natural persons such as the employers, and they're either retired or not employed. For individual contributors as well as entity contributors, a mailing address suffices under the charter and attendant rules. So the relevant charter provision is Article 13, Section 4D1B, which has a single reference to a residential address, which explains the distinction between employed individuals and unemployed or retired individuals. What it says is that when the contributor is an individual, the name and address of the contributor's principal business or occupation, the name and address of the contributor's employer, if self-employed, the address of the contributor's employer's business. If the contributor is retired or not employed, the residential address of the contributor shall be disclosed. And then when the contributor is an entity other than an individual, the name and address of the contributor, the business or activities conducted by the contributor, and the owners or managers of the contributor, again, shall be disclosed. So the only express requirement for a residential address is for unemployed or retired individuals. And if you look at the history of this charter provision, it did at one point contain a requirement for name and residential address. And then it was subsequently amended to omit any address requirement, mailing address or residential address. And then when the current version was adopted, it only included address. It did not reinstate that residential address language for all disclosures. So the inference from that is that the council, in amending this charter provision, made that decision consciously and thus did not intend that individual contributors who are employed and who do disclose their employer, including self-employment, a mailing address is sufficient. Now, there may be a question as to why is it different for individuals who are unemployed or retired? And you know, the history isn't clear on that, but it may be inferred that when an individual who is employed discloses their employer and the nature of their employer's business, that provides some information about the contributor that the public can then look to in making a decision on whether that affects their view of the candidate to who the contributor has provided funds. Whereas you don't have that information for retired or unemployed individuals. All you've got is the residence, which gives you where are they? Are they here in Albuquerque? Are they somewhere else? What part of town are they in? These are things that voters might find important. Now, what I've said so far doesn't fully answer the requester's question, because one of the examples is a retired individual who is traveling abroad and either does not have, which is what we're going to assume for the purposes of this, or would prefer not to use a residential address. Under the charter, if they've got a residential address, that needs to be disclosed. If they don't have a residential address, then the draft proposes to say that they can disclose none, but that needs to be accurate. A couple of reasons for that. One, it is accurate. And if they disclose a PO they're not required to do that. I think, though it's probably a good idea to get a PO box from your contributors who are, globetrotting and don't have a permanent address. And then also, although those who are in the city and do not have a residential address but may not have jobs, they may not be likely contributors, but the fact that they don't have a residential address should not exclude them from the political process should they so choose to engage. And with that, I'll take any questions that the board may have.
And hearing no questions, is there a motion with respect to the recommended advisory opinion?
Mr. Chair, I move that we accept the advisory opinion as presented.
So, Member Cuniff, is there a second?
I'll second.
Second down there? Mr. Green? Was it Mr. King rather down there?
Yeah.
And then, all in favor, say aye.
Aye.
Aye. Opposed? None opposed? Okay. All right. And thank you. Thank you for whoever turned down the mics a little bit. Okay, next we have on the agenda, we have discussion and potential action on advisory opinion AV 07-2025. And that one, Mr. Jackson, actually, I could use my mic down a little bit more.
Thank you again, Chair Marks and members of the board. The requester here is Carlos Sontag on behalf of the New Mexico Business Coalition. Yep. And the coalition seeks an advisory opinion on whether it can basically make an ad buy without having to register as a Measure Finance Committee. And this is perhaps a closer question than the previous advisory opinion. The coalition has attached the proposed advertisement, which is reproduced in your binders twice, once in the request itself and then once in the draft advisory opinion. And it is a photograph of what appears to be a homeless encampment. There are a bunch of tents there, shopping carts with that are full of various things. It's difficult to tell from the picture. And in the upper right corner, there is a white rectangle with block text that says ABQ had enough, vote November 4th. And then in the lower left, there is a smaller rectangle that says paid for by New Mexico Business Coalition. The requester represents that it's a 501c4 organization that has been in operation since 2009 and was neither formed nor operates for the sole purpose of influencing municipal, state, or national elections to benefit or oppose any specific candidates, ballot questions, or referendums. It also represents that it relies on member dues and donations to its general fund for operations and does not solicit money to influence elections. So the requester has broken this down in three broad questions on the proposed advertisement. One, in general, please confirm that expenditures of more than $250 from NMBC's general fund for Get Out the Vote ads that are limited strictly to nonpartisan voter participation and do not mention any candidate or ballot issue will or will not require NMBC to register as a Measure Finance Committee. And then specifically, please confirm that the ad in Exhibit 1 will or will not require NMBC to register as a Measure Finance Committee based on the 2025 rules by the Albuquerque Clerk for the Election Code and the Open and Ethical Election Code of the City Charter. Note, more than $250 will be spent on out of the NMBC General Fund to publish the ad. And then third, if the determination is that NMBC would not be required to register as a Measure Finance Committee, please confirm the disclaimer in Exhibit 1 is sufficient and NMBC is not required to expand the disclaimer to include top 5 donors and secondary donors. The proposed conclusion is that this proposed advertisement would, in fact, require the Business Coalition to register as a Measure Finance Committee. The principal charter provision at issue here is in the election code, Article 3, Section 4D1B. And it's the definition of a measure finance committee as a political committee or any person or combination of two or more persons acting jointly in aid of or in opposition to the effort of anyone seeking to have their name placed on the ballot for city office, a petition to place a measure on the ballot pursuant to Article 3 of this charter, voter approval or disapproval of measures on the ballot, and or the election to or recall from office of one or more candidates for office when such person or people have accepted contributions in excess of $250 or make expenditures in excess of $250 for any of the purposes listed heretofore. And then in addition to the charter provision, Part 8A of the 2025 rules for the election code specify that a measure finance committee includes one, any separate or segregated fund established by any corporation, membership organization, cooperative, labor organization, or other organization whose purpose is to initiate or influence a campaign or election. And two, any organization, including any corporation or association whose major purpose is in initiating or influencing a campaign or election and that receives contributions or makes expenditures aggregating more than $250 for that purpose, or any organization whose major purpose is not influencing candidate or ballot measure elections, but that receives contributions or makes expenditures aggregating more than $250 for the purpose of influencing the nomination or election of any candidate to office. The rules also specify that advocacy, charitable, or other organizations that are interested in raising and spending money to influence the election of a candidate, a ballot question, or a referendum are required to form an MFC for that purpose and file campaign finance disclosure reports with the city clerk. And that's Part 8B of the rules. So obviously the ad does not expressly mention any candidate. But in considering whether an advertisement seeks to influence a campaign or election, the context does matter. And there's no binding precedent on either the charter provision or the 2025 rules, obviously, because the 2025 rules are not, they're new. But if you look at, for example, the state regulatory structure under the CRA, it defines expressly advocate as including campaign slogan or words that in context and with limited reference to external events such as the proximity to an election can have no reasonable meaning other than to advocate the election, passage, or defeat of one or more clearly identified ballot questions or candidates. Now I'd note that also the election code includes one that does not have, that is a little bit broader, which is that where a reasonable interpretation is the intent to influence. And that statute, in fact, was upheld yesterday by the 10th Circuit in Rio Grande Foundation versus Oliver. This is a case involving a challenge to the requirement that the plaintiff disclose its donors. And then there are a couple of references here. One is to the Republican Party of New Mexico versus Torres, which rejected a challenge to the regulatory structure rather than the statute. And then Vermont Right to Life Committee versus Sorrell, which is a Second Circuit case. In other words, if an organization runs an advertisement for the objective purpose of persuading someone to vote for or against a candidate, but the advertisement did not identify a candidate in that election, it could still fall within Vermont's definition of influencing an election. And then the court rejected a vagueness challenge to that provision. Now here, the coalition stipulates that the expenditure requirement, $250, would be met. There are a couple of things in the request that end up not being material. One is the sole purpose, because a major purpose is sufficient to trigger MFC registration requirements. That doesn't have to be your sole purpose. And then the second is that they receive funds for various purposes, member dues and donations. But again, the $250 expenditure is by itself sufficient to trigger an MFC requirement if the communication would fall within the stated purposes in the charter and the regulation, i.e. influencing a campaign. So again, looking at the ad, the import is clear.
And let me interrupt just a second. Mr. Roach is attempting to put the ad up on the screen so for the audience here and for the audience on YouTube, so they know what we're talking about or you're talking about.
Certainly.
In case people are wondering.
The advertisement, you can sort of you can look at different hypotheticals of what might or might not trigger a registration requirement. If the rectangle in the upper right, I see we had it briefly. If the rectangle in the upper right was there, the message probably wouldn't be very clear. Had enough of what? Vote November 4th. That's unclear. I don't know whether that would be held by a court to require registration. If the coalition just had a billboard that said vote November 4th, that would not likely trigger the requirement. That would be very similar to the billboards that I'm sure that everybody has seen in recent years that county clerk had, saying, "Hey, we've got an election coming up. Go out and vote."
So vote November 4th without the picture.
Without the picture. But once you have the combination of had enough and the picture, there's a message there, and that message is, we've got a problem. We need new leadership. That's an intent. That reflects an intent to influence a campaign. I would note that in the current election, there is an incumbent in all but one of the seats that are up for election. The exception being, I believe, District 1, where one of the one of the sitting councilors is abandoning that seat to run for mayor. And had enough expresses a clear anti-incumbent sentiment, and without obviously opining on whether that sentiment is justified, that's political advocacy, and that's what the coalition is entitled to do. But with that comes the requirement to register as an MFC, and because of that proposed conclusion, it does not address the third question regarding the sufficiency of the disclosures in the event that registration is not required. With that, I'll take any questions that the board may have.
Mr. Chairman,
Yeah. Mr. Kelly.
you went really fast.
Can you turn on your mic, please?
But I'd like you to, the very last point that you made. I guess I'm not buying that you sitting at the table expressing an opinion about what the language means is appropriate. That's your opinion. It's not an opinion that has been, unless you've got authority citing to this or something very close to this. I'm not sure how it is or why it is that you're raising this in the fashion that you've done.
Hold off, Mr. Jackson. Mr. Kelly, I think you raise a point that I would address as follows. I think what Mr. Jackson has done for us is laid out the law in the first part of his opinion, laid out precedent that from some other jurisdictions that indicate that what our common sense indicates, which is that we can look at the intent of an ad, or we can divine it, but in any event, it's a fact question. Whether example one is I think he's given us a legal opinion that says if something is advocacy for or against a candidate, It requires to be registered as an MFC. The question of whether example one is advocacy, which I think is what you're objecting to, I think that's a fact question. And I think Mr. Jackson's given us his opinion, but this board's opinion is more important on that. And so what I would suggest is that if there's some debate among the board as to whether example one is advocacy for or against a candidate, that we do that. And I don't know that Mr. Jackson has any insight into that more than we do. Does that satisfy you, Mr. Kelly?
I'm not entirely clear what you mean by does that satisfy me?
Well, your question to Mr. Jackson is it appropriate for him to have an opinion on the fact question?
No, I appreciate that clarification. He's certainly entitled to have an opinion. But I'm not entirely sure I understand the capacity that he's giving the opinion from. If it's as our counsel, then I'd like to know that.
Yes. Thank you for the clarification. So the charter or the ordinance that we operate under has a provision about advisory opinions. And one of those is that when we get one in, we have, I think it's 2 weeks to get a draft of an advisory opinion. And it says that we could do it ourselves, or we could send it to counsel that's been engaged by the city clerk for that purpose. Mr. Jackson has been engaged by the city clerk to prepare advisory opinions for us. So he is our counsel in that respect. He's certainly not representing the requester or any campaign. He's attempting to be a neutral advisor to this committee, this board, and he's doing it pursuant to law.
If I may, Chair Marks and Member Kelly, the charter provision that discusses advisory opinions and discusses requesting outside counsel to draft the advisory opinion, which is then submitted, as I've done here, for the board's consideration to adopt, modify, or reject. The opinion needs to provide guidance to the requester, and the draft does that. If the board would prefer memoranda on the law, that would be submitted pursuant to the attorney-client privilege. That's something that I'm also capable of doing. But in this context, I did believe that it was important to answer the requester's question for the purposes of the advisory opinion. And that answer the answer that I've suggested may not be the board's answer. I do acknowledge that it's a close question, but the draft answers the question. And that is subject to acceptance, modification, or rejection by the board.
Did it better than me. Thank you.
I guess I would say that I don't view Mr. Jackson's explanation as trying to divine the intent behind the ad, rather to analyze the category of speech is it an artistic photograph, or is it a photograph that does have that does carry politically expressive meaning? And so I think Mr. Jackson's explanation that it falls into the category of politically expressive meaning is helpful, especially before we had it up on the screen for viewers. I would also, I guess, point out that the city clerk's rules do seem to suggest that organizations err on the side of registering as a measured finance committee. For example, Part A, B, as in boy, says requirements for advocacy or charitable organizations, advocacy, charitable, or other organizations that are interested in raising and spending money to influence the election of a candidate, a ballot question, or referendum are required to form an MFC for that purpose and file campaign finance disclosure reports. So if there's any, I guess, in the close cases where there may be doubts, the thrust of the rules is to, yes, register as a measured finance committee.
Mr. Green or Mr. Kuniff?
Mr. Jackson, thank you for your excellent work as always. I have sort of a statutory construction question for you, which is sort of the interplay between the charter provisions and the election code. Is the election code effectively the implementation of the charter provision?
Chair Marks just to clarify, when you say the election code, are you referring to the clerk's rules? Because nominally the Article 13 of the charter is the election code.
I'm asking essentially for you to explain to me the interplay between the two provisions you cite at the top of your analysis, the charter provision at Article 13 and then Part A of the 2025 election code.
Sure. So the election code, which is Article 13 of the charter, provides to the clerk the authority and the duty to promulgate rules to clarify and interpret the provisions of the charter for administration, as you see in context of any administrative regime. And the rules that have been promulgated here, they explicate and explain what the charter provision means. The charter is sometimes terse. This provision may be less terse than others, but the clerk who has had experience in running elections and has promulgated rules that are new for this year, although I will say that I don't recall whether this particular rule changed since the last cycle in 2021. These explicate and provide meat to the bones that is the charter provision. That's the basic principle here. Now, it may be that at some point a requester says that these rules go beyond what the charter permits in terms of defining measure finance committee. That would be a question that a court could evaluate, and that's not a question that was asked by this requester. But the basic idea is consistent with Member Cafferty's remarks, which is that disclosure is favored here. And one of the guiding principles that I've sort of gone with in drafting these advisory opinions, including this one for the board, is that when a requester tries to come up with something that's maybe a little clever, there's sort of an edge case on does this cross over the line? A permissible inference from that is that they are trying to influence a campaign without having to disclose, and that's not what the charter or the rules contemplate.
Because my sort of quarrel with the relationship between those provisions is that when I look at the charter provision, there appear to be 5 triggers for application of the standard, and they all, to me, are very specific. I think the 5th one is to influence the election or recall from office of one or more candidates. Are we operating under the assumption that it's the one or more candidates trigger that applies in a circumstance like this, where we're talking about what is really generalized campaign activity? Because presumably the candidates take different positions on issues that are related to this photograph, but this photograph certainly does not, at least in any overt way, seek to influence with respect to the prospects of any individual candidate or any particular group of candidates, from what I can discern.
Sure, Chair Marks and Member Cuniff, this is I think you've hit on one of the things that makes this opinion a little bit difficult is the charter provision. It says, again, it's got in aid, in opposition to the effort of anyone seeking to have a name placed on the ballot for city office. That's, I believe, 1. I just want to make sure that my categories track yours.
Yeah.
Approving place a measure on the ballot pursuant to Article 3 of this charter. 2, voter approval or disapproval of one. I believe it's 1 or more measures on the ballot, and or the election to or recall from office of one or more candidates. Now that one, it gets a little bit tricky here because you've got a long phrase and it's not clear which conjunctions are attached to which noun phrases. So is that really three, which is voter approval or disapproval of one or more measures on the ballot and or the election to or recall from office of one or more candidates for office? Is that one thing or is that three things?
But you'll, I guess, agree that the way that the rules have been promulgated suggest a more broader interpretation of influence. And that is something that has been upheld in other contexts as a First Amendment issue.
Chair Marks and member Cuniff, yes, it is, I would agree that the rules are perhaps broader than the charter provisions express language. But they are consistent with the case law that's been cited in the draft. Although, again, not with reference to these specific provisions, where, determining context and the general idea that that political advocacy permits requirements for disclosure. One thing that makes it a little bit difficult is that the Torres case, the Rio Grande Foundation case that came down yesterday, and the Vermont case, they're all dealing not with committee disclosures as such. Then it's not the Measure Finance Committee. It's not a PAC disclosure, but they're all talking about this in the context of independent expenditures that are in support or against an express candidate. And the independent expenditure language in New Mexico, as well as in the Vermont case, they talk about, expressly mentioning a candidate. The statutes do, right? Because that's how you determine, are they supporting a candidate? Is the independent expenditure in support of this candidate, in opposition to this candidate? And then the cases pull back from that and say, well, we can look at the context. And in the Vermont case, even if it actually doesn't mention the candidate, if the clear inference is there, then the regulation is permissible.
Thank you, Mr. Chair. Mr. Jackson.
Mr. Green?
Yes, so I want to kind of walk through this initiating and influencing. I think that that's the basis of this this requester submitting a ruling on this or an opinion on this. So looking at this, I think that context is key, and but I think with context with perception is a completely different issue. On this, they're addressing a problem and not an individual, right? So the influencing, would that be getting the public to vote more so than speaking to a certain party or campaign person?
Chair Marks and Member Green, I think it's probably best to refer to it in terms of candidates rather than parties, because by statute, the local elections are nonpartisan. But again, here, I think that the distinction between this proposed ad and the county clerk billboards that you've seen is probably instructive, right? It's not just saying go out and vote. It's saying had enough, go out and vote. It's expressing dissatisfaction with the current governance.
Well, and I would say I think it's more of a problem, isn't it? I mean, it's proposing an issue of homelessness more so than who's causing it, right?
I agree that it qualifies as influencing an election. So in Mr. Jackson's draft, on the bottom of page 2, there are some bolded, some words in bolded text. And I wish you had continued the bolded text to or elections. So in the city clerk's rules, one of the sub definitions of a measure of finance committee is any organization, including any corporation or association, whose major purpose is initiating or influencing a campaign or election. So I think influencing an election to increased turnout is influencing an election, which is different than the Secretary of State listing voting locations. That is information, rather than influence.
Chair Marks, Member Caffrey, if I could just make comment, just for informational purposes, the emphasis is not mine. That is in the regulations, and as it's a little strange, but
I'm not sure if this is helpful. May I ask one quick question?
Yes.
Is it, the language here seems to be quite precise. It says can have no reasonable meaning other than that to advocate the election. So it's incumbent, I think, upon whoever's making the argument that, it can't have a different meaning. It can't have a different meaning. I mean, we've got a lot of lawyers here and a lot of people who are very schooled in these sorts of issues, but this is for the general public. And I have difficulty coming to the position that some have that this picture and those words can have no reasonable meaning other than to advocate the election, blah, blah, blah. I just don't buy it. Factually.
Well, I think that is the key question. And as I said earlier, I think it's a fact question. I disagree. Mr. Kelly, I mean, when I saw this example, I interpreted it as a anti-incumbency measure. It's maybe it would be ambiguous if it didn't say had enough, but it's showing an issue that the current administration has been criticized for not addressing for several terms, and says had enough. I mean, clearly, the message is you vote for Mayor Keller, you're going to get more of the same. The Business Coalition may or may not be right about it. It's not, I don't have a position on the election. But to me, there's a message there that it's targeted at the current administration and saying it's not doing a good job, vote for somebody else on homelessness. That's how I read it. And it sounds like, Mr. Kelly, you read it as just vote for somebody.
Well,
I mean, if it was just vote for somebody, it would just be.
I think part of the problem is through whose lens do we look at this language? Do we look at it through the lens of the average voter, or do we look at through the lens of legal counsel, or through the lens of one or more astute politicians?
I think we look at it through the lens of a voter, but I'll make.
So once you look at it through several lenses, if you end up one on one side, one on the other, I think that the general rule in the charter and the clerk's rules is disclosure is favored. And the question presented here, all it is do we have to register as a finance committee? They can register, they can run as many of these ads as they want. All they have to do is report, which is not a significant burden.
Yeah.
There are plenty of measure finance committees who are registered, who do register, including of entities. We had a different advisory opinion question on which entities have to be listed as the top 5 donors. So the question presented is not whether or not they can run this, it's whether or not whether they should register as a measure of
Yeah.
finance committee.
Yes, good, great point. I, clearly, and I'm gonna disagree with, the last part of Mr. Jackson's recommendation. I don't think it really matters about who the business coalition is or what, what, I think what matters is the content of the, ad. And if they were, pure as the driven snow and they put this ad out, it, content still determines it, but it's clear to me that the business coalition intends that this ad have an impact on who people vote for, because otherwise they wouldn't spend their money. I mean, nobody with limited resources, i.e. nobody other than, the city clerk or the county clerk who can spend our tax dollars on promoting voter participation, and which is a good thing, but nobody who's organized as a political lobbying organization or has an interest in something is spending money just to tell people to vote. People spend money to influence an election because resources are limited. So I don't think their history or anything has any relevance, but I think it goes to the content. But the fact that they're spending money indicates to me that they believe it'll have an impact on who people vote for. But that's.
So Chair Marks, I guess we can vote to adopt the opinion, reject the opinion, or table it for if we want more context or analysis.
We could, and just to move things on, I think there's a bunch of questions here, but let's just do a straw poll. I think I heard if you believe that that this example is not advocacy for or against a candidate, can you raise your hand? We've got. I'm serious. I mean, if we get a majority for that, it's.
I'll split hairs here. I think it's influencing an election. So
Okay.
I would suggest I would adopt Mr. Jackson's opinion on that basis.
But yeah, let's do it that way. Ms. Caffrey, I'm going to take that as a motion to adopt the recommendation as presented. Is there a second for that? And then we will.
I second.
Okay, Mr. Cuniff seconded. And then the chair is going to make an amendment to strike on page 4.
You can't make an amendment after we do it.
Yeah, yes, I can.
Where are we?
Can we have both council opinion on that?
Robert's rules, you can move to amend a motion.
Okay.
You can move to amend, and if it fails, then we're back on the main motion.
Okay.
Do you follow me? Okay.
Yeah.
Yeah.
What's the motion we're moving to amend?
So the motion is that we adopt the recommended opinion as presented. That's the main motion.
And that opinion is what?
Is what's in front of us, which would hold that the holding would be that example 1 is advocacy within the meaning of the charter and the rules, and they would need to register as an MFC and otherwise abide by the requirements of MFC if they wanted to run that ad. Is that a good summary?
Chair Marks, that is correct. Although again, under 8B, they could also, they could form a measure finance committee to run the ad if they didn't want to register themselves.
Okay.
But
All right. So the motion is to adopt what Mr. Jackson has presented. It's been seconded. And what Mr. Jackson has presented in essence would require the entity that runs an ad similar to example 1 to be registered as MFC. And then the chair makes a motion to, on page 4, starting with the first full paragraph that says, moreover, although NMBC represents, to strike from there down to that stuff, CEG, HTTPS, all that stuff, and then strike because NMBC appears to have as a major purpose. I would propose to strike that and just make the opinion turn on the content of the ad, because I don't think NMBC's purpose is dispositive, and I think we'd come to the same, if we followed Mr. Jackson's logic, we'd come to the same answer if it was something new with no history or no charter or nothing. We knew nothing about the advertiser. I think we'd come to the same answer, and I think we'd come to a different answer if NMBC was proposing to run a completely anodyne, boring ad that didn't have homeless and didn't have had enough, or, just said vote November 4th, we'd have a different answer. So I don't think it matters. So that's my motion to amend. If there's a second, we'll discuss it. Just a second.
Just a point of clarification, so I know what we're voting on. So are you lopping off everything below that parenthetical for section 122(3)(b)?
Yeah.
Remainder?
Yes, everything except yeah. Yeah, and then I would keep that last sentence because the proposed advertisement is for purpose of influencing an election, and then put period there.
So just keep this last.
Yes, the
Gotcha.
last sentence, but just drop the reference to NMBC as being some kind of a political entity.
Chair Marks, just so I understand what the proposed modification is, may I read what I think the proposed last paragraph would be with the modification? It would be, because the proposed advertisement is for the purpose of influencing the nomination, election of any candidate or political office, had enough. Should NMBC engage in the proposed expenditures, it would have to register as a Measure Finance Committee. Is that correct?
That is correct. But if there's no second, it goes no further. Is there a second on that?
I'll second.
Okay, thank you. It's been seconded. Is there any discussion on the amendment? All in favor of the amendment, signify by saying aye.
Aye.
Aye. Opposed? Okay, the amendment carries. Now we're on the motion as amended, which is to adopt the recommended advisory opinion without the material about NMBC. Is there discussion on the main motion as amended? Hearing none. All in favor signify by saying aye.
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 Aye. Opposed?
Nay.
Okay. Motion carries, and let the record show that Member Kelly voted against it, and the rest voted in favor. I did receive an email from Ms. Sontag that she had wished to be here, but she's recovering from an injury. Carla, I wish you a speedy recovery, and thank you for participating in the process. With that,
Chair Marks?
yes.
Sorry. As has been done with the prior modifications, I will revise and provide to Cristobal for provision to the board for the final copy of this. And then also, I believe I don't have any further business. So
Okay.
with the board's
We
permission,
need to see.
I will leave.
But thank you, Mr. Jackson. I think this certainly was an interesting one. Okay. Okay, with that, we have item 6 on our agenda, an evidentiary hearing in BOE 03-2025, Tejas versus Forrester. And I'm going to start by taking appearances, and let's see, let's have everyone, let's move around here so we can get both parties at the table. So who appears for the complainant?
Good morning. My name is Jessica Roth, appearing on behalf of the complainant Stephanie Tejas.
Sorry, just if you can use this mic.
Okay, and let the record reflect that Ms. Tejas is here with you. And then who's appearing for the respondent?
Mr. Chairman, members, thank you. Antonio Maestas on behalf of Mr. Forrester, who's gentleman to my left.
Okay. And what we're going to do is we'll give each side 5 minutes to make an opening statement. We'll let you present witnesses, and then we'll let you do a close. And I propose maybe to limit the closings to 5 to 10 minutes. Before we get to any of that, Ms. Roth, who are you planning to put on as a witness?
Stephanie Tejas.
Okay. And Mr. Maestas, who are you planning to put on as a witness?
Mr. Chairman, we have no witnesses.
Okay. And do you intend to cross with Ms. Tejas?
Yes, sir.
Okay.
Sorry, just a reminder for this one, if you can press it for its screen and then you have to hold it up.
Thank you, Mr. Chairman. The respondent has no witnesses and we do wish to cross out.
Okay. And Ms. Roth, you're not intending to call Mr. Forrest?
Perhaps as a, do I have to push?
Yes, for it to be brief.
Perhaps as a rebuttal witness, depending on cross.
Okay. And then in terms of exhibits, Ms. Roth, do you have exhibits?
We do.
Okay,
Copies for all.
okay, and then, okay. Oh, they're not, it's not one big. You had me so scared.
I know.
I thought that was one big buck. All right, after the openings, and then Mr. Maestas, do you have exhibits? Well, you couldn't have exhibits with no witness, so.
We don't plan on it, but
What?
I made 2 copies of some stuff, but I don't plan on having any exhibits.
Okay, I mean, because if you want something admitted into the record, you're gonna have to do them through a witness. Okay, so,
Sorry, Chair Marks, just before we begin, I wonder if you want to provide a brief rundown for everyone who's watching about whether we're doing formal rules of evidence or not.
oh. That's a great question. Yes, we will. I accept that we will, as an administrative body, we will admit hearsay subject to the residual rule. Does that sound fair?
Yes.
Okay, and let the record reflect that member Selvin has joined the hearing and the meeting. Thank you. Okay. Any other procedural questions? Okay. I think it. Okay, with that, Ms. Roth, do you want to present, make an opening presentation?
Thank you. May it please the board, chair, and members. We are here today on what is a very straightforward issue before this board. The allegations that will be testified to by Ms. Tejas are that through the course of a phone call, Mr. Forrester, a registered campaign manager for a city council member, or excuse me, a city council candidate made an offer of an expenditure to retire campaign debt. And in the event that it was not accepted, that a lawsuit would be brought against Ms. Tejas. The definition in the city charter for an expenditure is the payment or furnishing of money or anything of value. Because Ms. Tejas did not accept the payment of money to retire her alleged campaign debts in exchange for not continuing with her campaign does not obviate the clear offer. The value that was provided to Ms. Chayes was the offer or the threat of the lawsuit. It is very important to note that Mr. Forrester made good on his threat. A lawsuit was filed against Ms. Chayes on September 2nd in the Bernalillo County Second Judicial District Court. And the evidence will show, Ms. Chayes' testimony will show that Mr. Forrester was very clear when he told her if she did not stop the recount and stop pursuing her place on the ballot, that one of the campaigns or anyone else would file lawsuits. The purpose of the articles in the city code, in the city charter, and the purpose, I believe, of this board is to preserve the public confidence in governing, ensure independence and impartiality, and keep decision-making rooted in public interest. When a campaign manager makes an offer, financial or otherwise, to another candidate, and then when that offer is not taken, follows through with the promise of what would happen if the offer was not taken, that is a clear appearance of impropriety, and doing nothing impacts the public's belief in the impartiality of this process. When Mr. Forrester and his legal team argue that Ms. Chayes' complaint should be dismissed because it is insufficient on
Objection, she doesn't know what we're gonna argue.
Wait, what's your objection, Mr. Maestas?
The gentlelady is saying that we're gonna argue this, we're gonna argue that, we haven't spoken yet.
I will rephrase and say that pursuant to the documentation provided by Mr. Forrester to this board in advance of today's hearing, his argument appears to be that there should be a dismissal based on insufficient procedure. But that again undermines the purpose. This board and these codes are for the general public. This is not a proceeding that requires legal counsel. It is stated that the purpose of this is for the integrity of the elections and the integrity of the candidates. A dismissal based on procedural issues that have since been corrected risks making this process look like a game rather than a safeguard of ethical conduct. There's been no denial in any of the documentation provided by Mr. Forrester and his counsel to this board of the alleged conduct that Ms. Chayes will testify to.
1 minute to wrap up, Ms.
Thank
Ross.
you. The violations of the city charter that we are here before you are in that there was an expenditure by furnishing anything of value, i.e. an offer to retire campaign debt, and if not accepted, a lawsuit would be filed, which has occurred, and the absence of reporting same. We ask that you find there's been an ethical violation, assess fees, and a written censure. Thank you.
Mr. Maestas.
Thank you, Mr. Chairman, honorable members. I'm not quite sure how to respond to the allegations because the allegations don't add up to an ethics violation. There are no parts or sections of the ethics code that were cited. And even if in light most favorable to the to the petitioner, even if we assume everything that they say is true, it does not add up to a violation. I know that that conversation rubbed Ms. Tejas the wrong way. It's very disappointing. We will show that Ms. Tejas was an applicant candidate. But Ms. Tejas knew the rules going in, that you have to have 500 signatures from registered voters who live in District 3. That she fell short, assuming the city clerk is competent. The city clerk went through 573 signatures, determined that 80 were rejected, putting Ms. Tejas at 493. She was in a heck of a predicament. There's no need, there's no embarrassment not getting signatures. It's a tough chore. What she's alleging Mr. Forrester told her is the same thing that 5 or 6 other friends told her. Hey, sorry, didn't make it.
Mr. Maestas, you have witnesses who are gonna testify to those facts? If not,
Yeah.
don't, what?
Okay, Ms.
Don't-
Tejas would testify if she was truthful, but okay, I understand.
Oh, okay, if you,
The,
no, if you believe you can establish that, I'm just,
The,
if-
yeah, no, I'll,
you get where I'm going.
thank you. No, thank you, Mr. Chairman, you're correct. So human beings are transactional. Politics is transactional. We don't want it to be solely transactional, but families do it all the time. What movie do you want to go to? Well, let's go to this show. If we go to this restaurant, hey, if you mow the lawn, you can use the car on Saturday. These things are they're not nefarious. They're not sinister. The evidence will show that Ms. Tejas and Mr. Forrester at the time of the phone call on July 11th were friends for over a decade. The allegations will not say, I'm calling on behalf of a candidate. The evidence will show that there was no offer of Mr. Forrester to give Ms. Tejas any money. There was no offer by any particular person. The alleged offer is, hey, I'll help you raise some money, retire your campaign debt. No one's going to give money to a candidate that is not on the ballot. The evidence will show that Ms. Tejas accumulated a campaign debt that she may still have. It's just a simple offer from a friend to get out of a heck of a predicament, a very public predicament. Ms. Tejas took it the wrong way. But the way Ms. Tejas took it is not the way a reasonable person would take that conversation, particularly someone who's in a political arena. Should Obama go to prison because he says, hey, Hillary, mellow out and I'll make you Secretary of State? Those conversations happen all the time. Human beings and democracy and self-government have taken centuries, millennials to perfect. 250 years ago, our country came close to perfecting it. When the most clear example is that in 1824, at the genesis of our democracy, John Quincy Adams defeated Andrew Jackson in a very contested race. It went to the House of Representatives, and the Speaker of the House, Henry Clay, became the Secretary of State. That was coined by Andrew Jackson as use his phrase, as a corrupt bargain. So I can see why someone would think that if they're in that frame of mind. But that's the way our democracy has evolved. That's the way these conversations take place, and they take place in families every single day. There's nothing manipulative. There's nothing nefarious. The evidence will show that it wasn't an or else. Mr. Forrester is a campaign manager. He knows this stuff. We know that every primary season signatures are challenged. He's giving her a heads up. Hey, if you continue with the rhetoric, chances are you're going to get challenged. And so despite 4 blast emails since this conversation and this allegation of stop the steal, there is no ethics violation here, Mr. Chair.
Okay. Thank you, counsel. Ms. Roth. You want to present your first witness and let's just go through the motion. You call your witness.
Certainly. I call Stephanie Tejas.
Okay, does anybody know the rubric? Raise your right hand. I'm gonna just wing it here. Do you swear or affirm that the testimony you're about to give is true and accurate to the best of your knowledge under penalty of law, perjury in the state of New Mexico?
I do.
Okay.
Ms. Tejas, can you briefly tell the board your professional background?
Sure, I am I'm a certified fraud examiner and forensic accountant. I teach fraud examination and forensic accounting for Anderson at UNM. I am the former director of the Government Accountability Office under the New Mexico Office of the State Auditor. And prior to that, I was an internal auditor for Wells Fargo Bank.
Ms. Tejas, did you talk to Mr. Forrester on July 11th, 2025?
Yes.
Why did you talk to him? What events led you to talking to Mr. Forrester?
The events that led me to talking to Mr. Forrester was I had received a phone call from a friend, and she had let me know that Mr. Forrester had contacted her.
Ms. Roth, I mean, we haven't heard the testimony, but you have a response?
My understanding is that the board was allowing hearsay.
We are. So you're not objecting, that's not hearsay. You're just saying let in the record. Okay,
That's correct.
that's easy. Continue. Stay as.
So I had received a phone call from a friend who informed me that Scott had, that Mr. Forrester had called her and inquired with her about how seriously, she thought that I was in continuing with my contestation of the petition signatures. She stated that she let Mr. Forrester know that I am very serious with it, and she let me know that Mr. Forrester let her know that his team had already done a review of petition signatures and that his review more accurately, shows that I missed it by more than 7, and that if I withdraw my contestation, they would help me retire my campaign debt. She further stated that Mr. Forrester said that if, I don't and I actually do make the ballot, that either one campaign or both campaigns or somebody else would file a lawsuit to have me removed from the ballot. She then informed me that she told Mr. Forrester, well, I'll let her know. And that was the end of our conversation. After that, I later sent a text message directly to Mr. Forrester that read, you could have just called me. Mr. Forrester replied, can you talk now? I texted back and I said, well, I'm on my way home. I'll text you when I get there. Mr. Forrester replied, okay. Once I got home, I sent a text message that said home and free when you are. And then I received a phone call from Mr. Forrester.
And what was the content of that phone call you had with Mr. Forrester on July 11th?
Sure. So we explained, pleasantries. It's true that Mr. Forrester and I have known each other for over a decade. So, we exchanged pleasantries, talked about our kids a little bit. We talked about the cat cafe, just taking my dog to the cat cafe. And then the conversation obviously switched to the topic of the campaign. I let him know that I did speak with our friend who he spoke with, and she shared with me what he had let her know and what he had offered regarding the status of my campaign.
Did Mr. Forrester deny to you that he had made that offer to your friend?
No. When I asked why he reached out to a friend instead of calling me directly, he said, well, typically campaign staff discuss matters with other campaign staff and don't generally engage with the client directly. I let Scott know I have no campaign staff. I am the campaign, and that my friend is just kind and generous and, you know, helping a friend out.
Did Mr. Forrester indicate to you that he was calling you as your friend?
No, he did indicate to me that he said he was calling his campaign staff to discuss campaign matters.
Please continue with the content of the conversation.
Sure. It was, you know, it wasn't the most comfortable conversation, I think, for either one of us. He began immediately sharing how, you know, uncomfortable it was to have this. He never expected to have a conversation like this with me. We both acknowledged, you know, our history, the friendly relationship that we've had over the years, you know, just our background, right? We acknowledged that. He then proceeded to just inform me of the same information and the same offer that my friend had shared with me. He went further to state that he had read the petition information and that their review showed more, that there were far more duplicates than that what he had tallied. And, you know, my contestation and audit request would actually hurt me more than help me. And he further stated that it, you know, will have an impact on the other candidates as well, but not to the effect that they would be impacted on the ballot. He then stated, you know, if you don't withdraw your contestation and you make it on the ballot after the review and that his analysis doesn't match, that he knows for certain that one of the campaigns or both or someone else will file a lawsuit to challenge the decision and have me removed from the ballot. I told him, okay, let them. I basically instructed him, like, I don't have control of other people. They are allowed to do what, you know, they have choice. I have choice. That the election code allows me to go forward with the contestation and the audit request. As an auditor, when you miss something by that narrow of a margin, it is reasonable to review it again. And so that's kind of the direction I was taking. I was also informed him that I'm going to use all the tools that the process allows me to use to go forward with this process, because I have a responsibility to my supporters. He then, you know, made some comments about how he understands, you know, he's known me for a long time, knows I have ambition to run for office. You know, there will be other opportunities in the future. And I, you know, let Mr. Forrester know that, you know, I have a responsibility to go through with the process. These are supporters, these are voters who sign my petitions. And I have a responsibility to ensure that they have their voices heard. And it's a narrow enough margin that as an auditor, a reasonable person, I think also would say, hey, 7 is a pretty low number. Let's review that. And so, you know, the conversation lasted another couple of minutes. You know, Scott again acknowledged that he's not happy that we had to have this conversation. We both, you know, acknowledged how much we have known each other, how friendly we've been, how we respect one another, you know, general kind compliments to each other. And then the conversation sort of ended around that period, I believe, if I'm remembering correctly. We did again talk a little bit about, you know, I did tell him kind of what my situation was in this process. I earned 573 signatures. I submitted 573 signatures. I did all this during a pretty hard situation in my life. My mom wound up going on hospice during the petition gathering portion. I'm her caregiver. So that was kind of difficult, obviously, during the process. But, you know, I still earned the right amount of signatures, and I'm going to make sure that they're counted. Again, it's just the right thing to do was to do this request. And then we exchanged some more pleasantries, and then the conversation ended.
Did Mr. Forrester during that conversation offer to help you raise money?
No,
Did he offer to give you money as a friend?
no.
What else did you do on July 11th?
That after our conversation, my conversation with Mr. Forrester, I then, texted my friend again, who I had the conversation with earlier, and I, let them know. I was like, sorry to bug you. Can you just call me when you have a chance? I just want to confirm what happened. Because through my head, I'm kind of spinning at this point, right? Like thinking, is this really something that's occurring right now? So my friend, she did call me back. The details of our conversation, again, were just, about kids, about family. And then I asked him again, I was like, what was that conversation that you had with Mr. Forrester again? Like, please just tell me again. And then she reiterated exactly the same conversation, that Mr. Forrester reached out to her, and that if I would withdraw or I don't move forward, that they will help me retire my campaign debt. If I do go forward, they will challenge it in court to have me removed from the ballot.
Did you speak with anyone else on July 11th?
I did. I spoke with another friend who also later, she confirmed that she also had a conversation with Scott. This is a different friend who is also just helping me, but she let me know that Mr. Forrester had also reached out to her and confirmed basically that Mr. Forrester, I shared the exchange I had with Mr. Forrester with this other friend, and she then confirmed that she had this same conversation with Mr. Forrester as well.
Let me interrupt you here a second. Mr. Myasis, you objected and called the court's the board's attention to hearsay when Ms. Hayes was talking about her first conversation with a friend. You haven't objected since then. Just so I know where we stand on the record. We've now heard about 2 conversations with friends, but also 1 conversation with respondent. Are you intending to argue that all of it is hearsay, or are you going to concede that the conversation with respondent falls into an exception with hearsay? I don't know, and it would help me in terms of what's in our record in terms of what's hearsay that we might let in because we're an ALJ versus what's hearsay. So it help me going forward by objecting if it's something that you object to, and also let me know right now if you're objecting to that Ms. Hayes's conversation that she alleges with Mr. Forrester, if you would concede that's an exception to either hearsay or not.
No, thank you, Mr. Chairman. Thank you, members. I didn't want to object ongoingly because I wanted to try to pay close attention to what Ms. Hayes was saying without interrupting. But what Mr. Forrester is alleged to have said is the hearsay exception. So we're fine with that. But whatever Ms. Hayes articulated that the 2 friends alleged definitely is hearsay and is not, I would suggest, is not admissible. So I could give an ongoing objection now or object every 2-3 minutes.
Without belaboring things, if you could just briefly, if it's something you believe is hearsay at the start of the line of questions.
Thank you. And Mr. I'll just object for the record. I don't want to argue the point, but I'll just put it on the record. Thank you.
Exactly, but I wanted to get out that the material, the testimony about Mr. Forrester, you conceding is an exception.
Yes.
Thank you. Okay, continue, Ms. Roth.
I'm sorry, may I briefly respond?
Yes.
I would argue that the conversations described that Ms. Tejas had with her friends are an exception because we're not offering them for the truth of the matter asserted. We are offering them to show why she took the action she took.
Noted.
Thank you.
Continue.
Ms. Tejas, after those conversations you had with Mr. Forrester and two friends on July 11th, what did you do next?
I sat in my living room in the dark and I thought about things for a while. And then I immediately just started writing down notes and recollections of these conversations so that I could remember accurately what happened. Yeah.
And in the days thereafter, what action did you take?
I then took action to file an ethics complaint. I did my due diligence and my research to see how and with what body I needed to file that with. And I made sure to follow the rules as I understood them, to provide the information that is requested for the ethics complaint, and I did that.
Why did you believe it was important to file this ethics complaint?
Because it was the right thing to do.
And what action are you asking the board to take today?
I am asking the board to take this information that I am providing with regard to my ethics complaint and to reiterate what you mentioned in your opening statement as the ask. And I'm not a lawyer and I don't know how to say this properly, but with regard to what's allowed in the rules, I believe it was fine and written censure.
Thank you.
Thank you.
I have no further questions.
Mr. Myastis, do you wish to, first, before we do that, are there questions for this witness from the members? Mr. Grinnell.
Can you share with us the identity of the two friends?
You know, I promised them that I would keep them anonymous because they are just my kind friends and generous friends, and they're people in the world, and I did not want to bring them into something that they were brought into without so I would prefer not to. I don't want to.
Mr. Grinnell, I don't think there's a privilege there if you want to force the issue.
No.
Ask the question again.
I think they've made their choice. The other question I have for you is, do you have the contemporaneous notes you took of these telephone conversations?
They were on my computer. I have them typed.
Council, do you intend to provide those to the
Are they in this?
board?
During the direct examination, and she didn't offer any documents. I mean, if you want them in, we could get them in, but if she didn't want to put them in, she would have.
I simply asked the question if they still exist.
They exist,
Yes.
but
They do exist.
we didn't take any of your exhibits into evidence because you didn't offer any.
And Chair Marks, Member Cunniff, I think the question about the identity of the friends, if Ms. Tejas declines to answer, we can, that kind of goes to wait if we want to consider that.
Okay. That's a great observation. Other questions for the witness? Okay, Mr. Myastis, you may cross the witness on her direct testimony and her responses to questions from the board. And then you'll have an opportunity to redirect Ms. Roth.
Thank you.
Thank you, Mr. Chairman. Just briefly, Ms. Tejas, good morning.
Good morning.
What I'm holding in my hand, Mr. Chairman, is the rules of the Board of Ethics and Campaign Practices. If I may approach the witness.
You may, but.
Or I may hand
But
it,
you
if I can hand this,
may approach the witness, but
understood.
she's if you're planning to ask her legal questions, I don't think that's gonna go anywhere.
I don't believe it's gonna go anywhere either.
I mean, I think we're here,
Can you,
so you can give it to her, you can ask the question,
thank you.
but.
So would you take that yellow highlighter, Ms. Tias, and open page and line and highlight the ethics, the part of the ethics code that you're alleging Mr. Forrester violated?
I don't think that's a fact question. This is my answer. I think you could ask her what sections of the code she alleged were violated in her complaint.
Thank you, Mr. Chairman. Ms. Tias, what sections,
Let her testify as to the law.
what sections of the code did you allege Mr. Forrester violated in your complaint or your amended complaint or your lawyer's entry of appearance complaint?
So in my complaint, it was the open and ethical elections code, coordinated expenditures, the rules of the Board of Ethics and campaign practices, and the city charter articles 13, 16, and 12.
Thank you, Ms. Tess. When running for city council, you're required to get 500 valid signatures.
Oh, I think you have to answer verbally.
Yes, yes,
And those valid signatures are registered voters that live within the District 1.
yes.
Okay,
Could you, I'm having a problem here. Can you
Oh.
make your questions in the form of a question?
understood. Thank you.
That's-
Thank you, Judge.
I didn't hear a question in the last one. So I can't say anything.
And is it true that you turned in 573 signatures?
Yes,
But the city clerk rejected 80 of those signatures.
Again, Mr. Mayor.
I'm sorry, isn't it true that the city clerk rejected 80 of those signatures?
yes,
And did you try to, Ms. Tejas, did you try to rehabilitate any of those 80 signatures?
yes.
How so?
With the rehabilitation forms provided by the city clerk. I also requested a written contestation and audit with a scope.
And Ms. Tejas, do you have any of those contested forms with you today?
Objection, relevance.
Credibility?
We're not here on Ms. Tays's.
How does it go to her credibility, Mr. Francis?
I don't believe they exist.
So we don't have a. Can you refresh my memory? What was the response to the last question?
About if I submitted the 573 or I don't.
So Ms.
I'll rephrase.
Refresh my memory.
I'll rephrase, Mr. Chairman. So Ms. Tejas, did you just ask them to count again, or did you specifically contest their rejection determination of particular lines and names and signature?
But that doesn't go, I mean, your point is you think she's testifying untruthfully about something?
Well, that's not my point, but that's the reason I asked her to produce the documents.
But it's.
Okay, I'll move on, Mr. Chairman. I'll move on. This should be
I
quick.
think
This should be quick.
the signature thing is just not what's before us.
Understood. And so Ms. Tejas, after so on July, I'm sorry, withdrawn. So Ms. Tejas, the city requires signatures to be collected. Is it true? City requires signatures to be collected from June 2nd to July 7th?
Objection, relevance. The chair stated.
Okay.
Okay, and so I'll withdraw. And so what happened on July 10th? What did the city tell you on July 10th?
Objection, relevance.
What's your response? We don't.
I mean, it just goes to the relevance of the conversation on July 11th.
No, because it's before it's the day before the conversation. Please answer. What did the city tell you on July 10th?
The city clerk posted their final tallies on their website and then provided candidates with an email of the final tallies, wherein they stated that I, to their review, failed to meet the 500 signature threshold by 7, and I'm at 99% and not 100% of the 500.
Ms. Tejas, the 2 or 3 days following that announcement, or I'm sorry, withdrawn. So that announcement wasn't just to you, it was to the world, correct?
Correct. It's on the city's website. Anybody can go look at it. It's public record.
And so presumably everybody who's kind of a political junkie was aware that in the opinion of the city, you didn't have enough valid signatures.
It's speculative.
Okay, thank you. And so in the 2 or 3 days after that announcement, was your phone ringing a lot?
Objection, relevance.
Overruled.
I mean, comparatively to every other day that it rings a lot. I'm a mom, I'm a caregiver, my phone rings a lot every day. So yeah, my phone was ringing.
And so after the conversation with Mr. Forster, you documented as best you could that conversation?
Yes,
And is it fair to say your recollection was better then than it is now with regards to that phone conversation?
I mean, I documented it immediately so that I could be as clear as possible. I say my recollection of the event from then to today is still just as clear.
And Ms. Tejas, that it wasn't necessarily a transcript, but that documentation that you did that day, you typed it up and it's part of your addendum in your complaint, correct?
The documentation regarding the conversation is part of the original complaint as the narrative and timeline.
Understood. So it was attached to the complaint.
Yes,
And do you have a copy with you today
of the complaint.
of the attachment of the conversation, of the documented conversation that you wrote down soon after you spoke to Mr. Forrester on July 11th?
Yes, I have a copy of it. It's also public record and available for anybody on the city's
And Ms.
website.
Tejas, could I ask you to glance at it and show me on that document where you documented something to the effect of, I am calling on behalf of a campaign?
He said typically campaign staff discuss matters with other campaign staff and don't generally engage directly with the candidate. And that was I interpreted that as him calling on behalf of the campaign.
Understood. But isn't it true, Ms. Tejas, that he didn't say staff call staff, but he said, I called your staff?
He did at the end of our conversation. However, he did mention that Aaron is his client.
And could you point to, once again, the where you wrote down as best you could the conversation within an hour of the conversation actually happening? Can you please look at that document and show me where you wrote that down?
Yes, page 4 at the very top, second sentence of the timeline and narrative.
Did you read that for the record? We're not looking at the document.
He responded very adamantly that he would not answer and that Aaron is his client.
And Ms. Tejas, did you agree with the city that you fell 7 votes short?
Objection, relevance.
Will respond.
You, despite the city suggesting you were short, you took those petitions and turned them into the county clerk?
Objection, relevance.
Is that a new question?
Simple question.
Okay, so you're giving.
Isn't it true that you took those signatures that were deemed short by the city clerk and gave them to the county clerk?
I will renew my relevance objection and also object that it's outside of the scope of my direct.
I'll withdraw. We'll finish up,
I
Mr.
think I'm
Chairman.
I think you have the ability, Ms. Tejas was listed as a potential witness, so I'm gonna let him go outside. But he's conceded on relevance, so let's go on.
Yeah, so. Then you've known Mr. Forster for over a decade,
Correct,
and you know he does campaign work,
correct.
and so that's his profession, right?
Mhm.
You have to answer yes or no.
Yes, it
And
is.
did his predictions come true?
His prediction about filing a lawsuit against me? Yes,
And you testified moments ago that Scott told you either one of the campaigns or both or somebody else is likely to file a lawsuit against you.
yes, Mr. Maestas, you filed the lawsuit against me.
And so it wasn't one campaign or both, but actually somebody else, two registered voters.
It was somebody else you filed the lawsuit against me as the attorney for somebody else. Yes, Mr. Maestas.
And actually, for the record, it's not against you, it's against the county clerk. Is that correct?
It is. I am a person of interest listed on
The,
the
Well,
complaint.
Well, I'll just, yeah, and just lastly, is the example I gave, if a teenager agrees to mow the lawn in exchange for using the car, is that a quid pro quo?
I don't know. I only have a 5-year-old. I don't have a lot of experience with children being asked to mow the lawn. That's not an example, but it sounds like it's something a parent would ask their kid to do if they wanted something. If a parent asks their child to mow the lawn, it's not against the law to do that. There's no statutory law against parents parenting their children.
Ms. Test, did you have similar conversations with friends with regards to your campaign after the city rejected 80 of your petitions?
I have lots of conversations with friends about my campaign.
And the friends the two friends that shall remain nameless, those are also Scott's friends, correct?
That is correct. That's my understanding. Yes.
So you're alleging he called a mutual friend to communicate with you with regards to your campaign.
Yes.
And then you insisted, well, why don't we just talk? And he talked to you about your campaign.
Yes.
And did he offer to give you any money?
No. He offered to retire my campaign debt.
Actually, isn't it true he offered to help you retire the debt?
He offered to help me retire the debt. Yeah.
And you didn't take him up on that help.
No.
But instead you wrote a letter to the Attorney General alleging criminal violations.
Yes.
And you wrote a letter to the Secretary of State alleging criminal violations.
Yes.
And you wrote a letter to this honorable or the clerk, rather, the city clerk, alleging criminal violations.
Yes.
So you were upset.
No, I was presented with what I believe to be bribery. So I filed them.
But Ms. Tejas, if the district court does the math at Friday's hearing and you're not on the ballot, isn't that the same outcome as what your then friend Scott Forster suggested?
Objection calls for speculation and relevance.
Do you want to respond to the objection?
She's alleging some nefarious threat, and I'm just pointing out that he's giving her predictions that panned out.
Overruled, answer the question. Do you agree with?
What, can you repeat the question?
If after the hearing, after the petition challenge hearing, if the county clerk does not put you on the ballot, isn't that the exact same outcome that would have happened if you would have taken your then friend Scott Forrester's advice?
I didn't get advice from Mr. Forrester. And no, I'd have to just go to court.
With one exception, of course, Ms. Tejas, if you would have taken Mr. Forrester's advice, you would not have a campaign debt today, or you may not have a campaign debt today.
Don't, and you can see the public financing reports show I do not.
So an
I
old,
wasn't clear. Are you testifying you don't have campaign debt? Well, is that your testimony?
Yes, that is.
Okay.
and so an old friend that you've known for over a decade who is in the profession of campaigns calls you the day after the city rejects your petitions and explains your political situation. And instead of considering his advice and counsel, you decided to throw him under the proverbial bus.
An old friend who is now the campaign manager of an opponent in a race that I am in for city council called me and made these offers.
And Ms. Tess, do you have documented proof that Mr. Forrester was the campaign manager in July, on that day, July 11th?
There is, it's on the record from the last hearing from the city clerk's office. They testified that Mr. Forrester is the campaign manager for Mr. Griego.
And Ms. Tess, what date did Mr. Forrester become the campaign manager for Mr. Griego?
I don't know.
So Ms. Tess, you have no documented proof today that Mr. Forrester was the campaign manager for Griego when this phone call was made?
I don't have access to Mr. Forrester's work documents or clients.
But Ms. Tess, on the city website, when you have to disclose who your campaign manager is, doesn't that, if we were to look right now, wouldn't it have a date on it?
I don't know what the city clerk publishes, what their required publish requirements are.
So city ordinance, Ms. Tess, says you collect signatures from June 2nd to July 7th. Is that true?
Yes,
And you fell 7 signatures short according to the city?
according to the city.
And so isn't it true that in August, you collected 8 more signatures and gave them to the county clerk?
Objection.
Contrary to
Relevant.
city ordinance and contrary to state law?
What's the objection was relevance?
Relevance.
And what's your response, Mr. Francis?
It just goes to credibility, the determination and the misgivings as to the reality of the situation that Ms. Tejas is just determined to move forward despite the procedural hurdles that she was unable to overcome.
Sustained.
Thank you, Mr. Chairman. No further questions.
We have any redirect?
Briefly. Ms. Tejas, in your conversation with Mr. Forrester on July 11th, did he tell you that Mr. Griego was his client?
Yes,
I have no further questions.
Any further questions from the board based on anything you've heard from this witness?
I just had one point. And Ms. Tejas, it's the wording that you've used to describe this exchange with Mr. Forrester. Did he offer you money to retire the debt, or did he offer you assistance in retiring the debt?
he offered to help me retire my debt.
Thank you.
Let's do closing and I would encourage after each attorney has made their presentation, if the members have questions about either the facts that they're arguing or the law that they're arguing, they can ask after each presentation. So Ms. Roth?
Oh, sorry, Chair Marks, do you want to give a time limit?
I think I did, but maybe I didn't. How long do you think you need, Ms. Roth?
For my closing,
Yeah.
5 minutes.
And Mr. Maestas?
3, Your Honor.
Okay, 5, we're gonna go with 5. 10 meters.
Right.
Please proceed.
Thank you. The board has heard uncontroverted testimony that a call occurred on July 11th of this year in which a political operative representing a candidate in opposition to Ms. Tejas offered to furnish money in exchange for her to stop her challenge, and stated very clearly and unequivocally that if that challenge was not withdrawn, then a lawsuit would be filed by a candidate or by someone else. Mr. Maestas spent a lot of time pointing his fingers at Ms. Tejas and the reasons why he is assuming that she is doing this. But the reason that she is doing this is a board of ethics making an offer in the political arena to cease your candidacy in exchange for money or the threat of a lawsuit is an unethical behavior. The city charter is very clear about expenditures and reporting. Just because the offer of the expenditure was not accepted does not make the offer not double negative, but it's that offer is still an ethical violation. The purpose of the legislative intent behind these rules is to maintain transparency and ethical standards in the political campaigns and election process, and allowing this to occur with no consequence and turning a blind eye on what Mr. Maestas seems to be arguing is politics as usual undermines the purpose behind this board and the purpose behind these articles of the city charter. This is not a teenager mowing the lawn in exchange for an allowance or families negotiating dinner and movies, as Mr. Maestas pointed out. This is a person representing an opposition candidate offering a bribe. That at its heart is an unethical conduct that should be for which there should be consequences, including a fine and a public censure as provided for in the city charter. Continuing to say that Ms. Tejas did this because she was angry or because she didn't make it on the ballot is giving more fire to this idea that politics and politicians are corrupt and that the public cannot put trust in those who are running to represent them. On a local level, these folks are our neighbors and our friends, and we have to, as citizens and residents of the city of Albuquerque, be able to put our faith that this board and that those that we are electing or attempting to elect are upholding the highest standards of ethics. We ask that you find an ethical violation of the city charter was committed by Scott Forrester in his uncontroverted, I cannot put too fine a point. He did not deny that he made these offers. He did not deny, and as Mr. Maestas so rightly pointed out, what he alleged or quote unquote predicted has come true, because Mr. Maestas himself filed the lawsuit naming Ms. Tejas as a party in interest. And when we look at this through the lens of the appearance of impropriety, that's all we can see. So we ask the board to find that there's been a violation and to fine and censure Mr. Forster. Thank you.
Questions from the members? Ms. Ross, Mr. Knuth.
What I'm trying to pinpoint is what we hang our hat on in terms of what the violation is, right? And I think that your argument is that Mr. Forster's actions violate the coordinated expenditures provision. Is that right?
That's correct. And the appearance of impropriety.
Do you happen to have that in front of you?
In the city rules or in the city charter?
The rules that include that part 6 referencing coordinated expenditures. I think it's page 11 and 45 in my copy.
I do have it.
The previous page, there's an enumeration of 4 different types of expenditures. Can you describe for me which one of those 4 Mr. Forrester's conduct is encompassed by and why?
My understanding is that the rules from the city clerk are promulgated, but that the city charter controls. The city charter defines expenditure of payment or furnishing of money or anything of value. And so he did not pay a loan as defined on Part 5 expenditures of the rules, but the city charter in Article 13 of the election code defines expenditure, which is Article 13, Section 2, subparagraph 4R. Expenditure means the payment or furnishing of money or anything of value, or the incurring or repayment of indebtedness or obligation. That is the definition of expenditure.
So your position is that this sort of enumeration of expenditure types in Part 5 is not applicable?
It is overly narrow and that the city charter would control.
Well, isn't the purpose of the code to implement the charter provisions?
It is, but they can be easily changed. The city charter is not as easily changed, and I am not aware of any challenge to this definition of expenditures, but it is clearly made, it clearly changes the definition that's in the city charter.
So the question I asked you at the outset, without having a debate about whether or not it's faithful to the language of the charter, do you will you offer to me what you think the alleged misconduct by Mr. Forrester, which one of these 4 cover that conduct?
I will concede that by this narrow definition, his offer of a bribe to retire campaign debts or else get sued is not one of these 4 very narrow definitions of expenditure.
Okay. And I just had one more question and I'll be done, Mr. Chair. You've recommended that the board impose a fine on Mr. Forrester. Do you want to tell us what you think that fine should be?
we would defer to the board to fine in accordance with the abilities or with what has been tasked to them.
Okay, thank you very much.
Of course.
Before we go to the rest of the members here. You're relying on the definition in the charter under that paragraph R, the definitions, right?
Yes.
Okay. And to re-ask Mr. Kunev's question. What part of that definition was satisfied?
I will also note that the same definition appears multiple times in the city charter. It's also in section 16, open and ethical elections, the same definition for expenditure. It is the furnishing of anything of value. That is the piece that we believe what was furnished of value to Ms. Tejas was this offer to retire campaign debt. She didn't accept it. But the furnishing of the offer is the unethical conduct.
So
If Ms. Tejas had accepted that, then she would have also been in the wrong.
So you're arguing the word furnish means offer without requiring actually to be delivered. I'm not going to say acceptance, delivery. There's no delivery here, correct?
That's correct.
Okay.
I am saying that furnishing is the promise that was made. The thing of value was the retiring of the campaign debt that he wrongfully assumed she had. And there was no delivery because she didn't accept the bribe.
So if the Can you connect that to, so say we agreed with you that the offer satisfied the word furnish in here, then it becomes an expenditure, right?
Yes.
Okay, and then expenditures are not illegal or unlawful. What's illegal or unlawful is not reporting them, correct?
That's correct, and it has not been reported.
Okay, and who reports?
It's a coordinated expenditure, and so an expenditure is presumed to be made in cooperation, consultation, or concert with, or the request of a candidate. Mr. Forrester said to Ms. Tejas that Mr. Griego was his client.
Okay, so you're saying the Griego campaign should have reported an offer on their campaign finance reports?
That is what is required of the rules in the city's charter.
That and yeah. And I've got to follow up that, but I'll go back to the board here. We have some questions.
I just want to do more quickly. So under the scenario that you just discussed with the chair, what value would the Griego campaign have assigned to that coordinated expenditure?
I don't think that it is Ms. Tejas' responsibility to assign value to that. I don't know what the value is, but I can tell you that it could have been, had there been campaign debt, whatever they retired, it could be the cost of her time and now having to defend a lawsuit filed by Mr. Maestas that was promised as part of this. Her legal fees, if any, associated with that lawsuit.
But those are expenditures by her.
that she's required to do because she did not accept the original offer.
Thank you.
Ms. Roth, on the, can you look at section 10 of Article 13?
Yeah.
Called enforcement.
Yes.
First of all, you're not doing your job. I had my mic off this whole time. Okay, so is Ms. Tejas' complaint brought under section 10? A,
10A, yes.
it is?
Under the rules and regulations?
No, I'm talking the charter. The charter, we're in section 10, it says enforcement,
Yes.
right? Charges of violations. Is Ms. Tejas' complaint made under this section? Or is it made under some other authority?
My understanding is it's made under this section of enforcement.
And because this is the section having to do with complaints, correct?
Yes.
Okay. A2 says a charge or charges that a candidate or the chairperson of an MFC has committed a violation shall be made in writing, et cetera, et cetera.
Mm-hmm.
Is Mr. Forrester a proper party?
Our argument is that that his behavior was done on behalf of the candidate.
But but you're not alleging are you alleging the candidate is violated?
The candidate didn't contact Ms. Tejas.
But
Forrester did.
But you told me 5 minutes ago that the reporting violation was that the Grego campaign should have filed some kind of a report. That's the violation. That's the Grego campaign is the violator. If an unlawful bribe was done on he's the agent of the campaign, I think there's been some question asserted as to whether he was an agent on that date, but assuming that he was, he's not the candidate. But how do we, and he's not the one who didn't file a campaign report. He's somebody who did something that seems, to some people as being unethical and but is he under our jurisdiction?
I believe he is under the same Article 13 and under Section 2 definitions F. Candidate Finance Committee consists of the candidate, the candidate's treasurer, and any person authorized either expressly or by implication by the candidate to participate in the solicitation, receipt, expenditure, or employment of contributions on behalf of the candidate.
Thank you. So, and and on that same point,
Yes.
okay.
But your position is that we can find Mr. Forrester individually and not the Grego campaign?
I defer to the board on who the fine is assessed against.
So So a slightly different point. I think we're focused on the something of value. And I think you would argue that whether he offered to give money or offered to help raise money, he's a professional, so that's an in-kind. And I would agree with you on that. I don't know if I'd agree about delivery, but the whether or not they file a lawsuit, is that something? Are you still arguing that actually is something of value, or that that's a violation, that the threat or offer to not file a lawsuit if she concedes her candidacy, but I'm going to file a lawsuit if she continues? I mean, there's nothing unusual about that, is there? Or nothing improper, is there?
Certainly, anyone has a constitutional right in the United States of America to file a lawsuit.
Right.
And so, no, the filing of the lawsuit is not an unethical. We are not at all saying that the campaign or Mr. Maestas or anybody coordinating with one another on these issues had a right to file a lawsuit.
Didn't have a right.
We're not saying they didn't have a right. That's correct. I'm sorry. What we are saying is that it ties in to the offer of something of value, that the value was what would have been if it was accepted, primarily the retiring of debt had she accepted it. But the fact that she didn't accept it shows that the offer of the thing of value actually had value to that campaign because they followed through on their threat. And you heard today the singular focus on Ms. Tays's collecting of additional signatures and submitting them to the county. That has nothing to do with what we're here for today. That is all the lawsuits that Mr. Maestas has brought. And so it's a mixing of the issues. I started by saying it's a simple issue. An offer of a thing of value was made and unreported. And I think that there's been no testimony or evidence presented to the contrary.
Further questions? Mr. Maestas, do you want more than 3 minutes?
4, Mr. Chairman.
Okay. Proceed, please.
Scott Forrester called Stephanie Tays and offered to help. Called a friend and offered to help. Offered to help her retire a campaign debt. There's no evidence presented today, Mr. Chairman, honorable members, that he called on behalf of anyone else other than himself. We appreciate the conscientiousness of this board and taking time out of your day to be here this long. But we heard no evidence that he promised to give her anything other than to help her retire the debt, presumably from mutual friends. The friends that Ms. Tays alleges Mr. Forrester called are also Mr. Forrester's friends. He's trying to communicate something that is not communicated somehow. Ms. Forrester suggested that she filed this ethics complaint to, quote, do the right thing on behalf of others. Well, what about the right thing with regards to Mr. Forrester? You know, being blasted in the papers and being here on YouTube now. How can that be right? There's what the petitioner is saying is this is unethical behavior. This cannot stand. Find something in the code to deem unethical. These interactions may rub folks the wrong way. Log rolling, for example, amongst a legislative branch. If you vote my bill out of committee, I won't argue your bill on the floor or whatever. That seems kind of weird to folks, but what folks might not understand, and I think Socrates said this, all human beings are political animals. we do politics every day, we just don't realize it. And so a lot of these interactions are in fact quid pro quo, but they're not nefarious, they're not sinister, they're not bribes. You know, a couple examples, Mr. Chairman, one family member hosts Thanksgiving, one family member hosts Christmas. There's no threat. If frankly the phone call was like, my friend, I wouldn't do that if I were you. If you go through this park, if I know that if you walk through this park behind the street, these kids are gonna throw tomatoes at you. Hey, man, I wouldn't walk through that park. You may want to go around. Well, why? Well, if you do, I think these kids might throw tomatoes at you. That's a warning. That's a friend. That's a heads up. He has nothing to do with the tomatoes or the kids. If you move forward with 493 valid signatures, one of the campaigns or both of the campaigns or someone else will probably file a lawsuit against you. There's consequences to moving forward in that regard, and Mr. Forrester simply informed her of that given his vast experience as a campaign manager and caring about her as a friend. And I would suggest at that time a true friend. Because those conversations are hard. For the folks that were calling Ms. Tejas the 2 or 3 days after that fact, there's probably maybe more friends that didn't make that call. If Mr. Chairman, if I walk into a reception, I have like a moco on my face. There's some people that aren't going to tell me. Someone's going to say, hey, Mo, man, hey, here's a Kleenex. You have a moco on your face. That's hard. That's uncomfortable. That's awkward as heck.
Well,
but that person that tells you that, I believe, is you can only consider them a true friend at that time. So to make a long story short, Mr. Chairman, it's just unfortunate. I think Ms. Tejas truly believes that was just a heinous act. We're not going to convince her otherwise. I suggested it was an act of a friend, but nonetheless, it's not unethical by any stretch of the imagination. I'm not going to get into this whole expenditure rabbit hole that just doesn't apply. There's no appearance of impropriety. There's really nothing other than, hey, sorry you didn't make it. Here's what I think you should do. Thank you, Mr. Chairman.
So Mr. Mayestas, if I loan Mr. Kelly $10,000 and we're acquaintances or friends out, I mean, the board members, I know him outside of this. So if I loaned him $10,000 and a few months later, he hasn't paid me back, I say, John, pay me back that $10,000 already. If you don't, I'm going to sue you. Is that the action of a friend or is that action of a creditor?
Mr. Chairman, I think maybe both. But it's certainly not a threat. A bribery or a threat implies that somebody do something illegal or nefarious. What the alleged Mr. Forrester asked Ms. Tejas to consider maybe the exact same outcome that's going to occur. You're not,
or
someone cannot drop out of something they're not in. But anyway, I think I think both, Mr. Chairman, a friend and a creditor.
Thank you. Questions for Mr. Mayestas? With that,
Mr. Chairman.
yes. Yes. You want to know when you can get the $10,000? Proceed, Mr. Kelly.
There's, am I right that during all of the events that we're talking about, Mr. I'm sorry, Mr.
Forrester?
Forrester, I'm sorry. Am I right, counsel, that Mr. Forrester has been representing a candidate for office who was for the same position that Ms. Tellis is running for?
Mr. Chairman, Board Member Kelly, there's evidence that he was working with Mr. Grego. There's no evidence that he spoke on behalf of Mr. Grego, but city documents will show as of August 1st, Mr. Forrester is Mr. Grego's campaign manager.
Okay, well, so I think the answer is yes.
Today, yes, Mr. Chairman, Board Member Kelly, but not on July 11th.
There's no evidence either way, I think is what we heard, Mr. Kelly. We heard evidence that he said he was. Ms. Roth, what's the claim?
That Mr. Griego was Mr. Forrester's client.
So not a campaign manager. What's the pleasure of the board? I think we can get a motion to sustain the complaint and the penalty. We can get a motion to deny the complaint.
I believe we can also have a motion to go into closed session if we
Good.
want to further discuss.
Yes,
The-
that is correct. Entertain any of those motions, or even a motion. We'll even take motions to table.
Well, so I will make a motion that the board go into closed session pursuant to NMSA 1978, section 10-15-1H3 to deliberate on the evidence received at the hearing, which has been held before the board in case number BOE 1-2025.
Is it
Second, Mr. Chairman.
okay? There's a
Point of order, I believe this is actually BOE 03-2020.
Okay,
okay. Thank you. And
do I have to repeat that?
no,
Okay.
that's so. The motion is to go into closed session to discuss this. And certainly, I'll just advise the board members it's not required that we do that, but we're allowed to do that. I'm going to have the clerk call the roll, the vote up, yes or no on the motion.
Member Caffrey,
Yes.
member Kuna,
Yes.
member King,
Yes.
member Kelly,
This is to go into executive session.
Yes.
correct? Yes.
member Green,
Yes.
member Selvin,
Yes.
Chair Marks.
No. Okay, motion passes. We're gonna go into closed session.
Mr. Chairman, do we exit or do you?
No, we got a little room there. Yeah.
We're live.
Okay. So in closed session, the board deliberated the matter before us in the complaint and did not discuss any other business and took no action. The board did vote to return from closed session, but we will take that vote again in public so it can be on the record. Is there a motion for the board to come out of closed session?
So moved.
Mr. Kunis, second. Mr. King, all in favor signify by saying aye.
Aye.
Any opposed? Okay, board's out of closed session. And is there a motion?
Yes, I move to find that the complainant has not proven by a preponderance of evidence a violation of Articles 12, 13, or 16 of the city charter.
Is there a second for that motion?
Second.
Second by Mr. Green. Is there any discussion of that? And I will allow the members to make comments afterwards if they want to provide some more insight to the parties. Is there any discussion of the motion on the record before we vote? Hearing none.
Sorry, I'll for some discussion. The board's jurisdiction generally goes to candidates and measure finance committees and candidates and measure finance committees. And as such, it's unclear or absent in the city charter whether the board has the power to take action or take enforcement against an individual working for a candidate or on behalf of a candidate, even if that person is officially designated as a campaign manager. It is still the board's enforcement power does extend to candidates and measure finance committees. So that is part of the rationale here. Additionally, whether or not an expenditure occurred, the expenditure, even if offered, was not completed or delivered.
Any further discussion? Let's do a roll call.
Member Caffrey,
Yes.
member Cuniff,
Yes.
member King,
Yes.
member Kelly,
No.
member Green,
Yes.
member Selvin,
Yes.
Chair Marks.
Aye. Motion carries, the complaint is denied. Do any other members wish to comment and beyond what Ms. Caffrey has said? Mr. Kunis?
My only comment is that it isn't a comment by the board, I don't think, on the factual allegations, right? I just don't think we really get there because of it not really being a fit for our authority. And I think that sometimes it's important to remember that bodies like this one have limited authority, and we are duty bound to stay within that limited authority. And I think you've implicitly recognized that by taking your concerns to other regulatory and agencies in New Mexico who may have jurisdiction over the allegations that you've alleged. But it's important, I think, that the people who are under our jurisdiction be on notice with respect to what we can enforce and what we can't. And I just don't think this falls within that rubric. So thank you.
Thank you. Thank you, members. Thank you, council, and Ms. Tejas and Mr. Forrester for coming here today and allowing us to do the people's business. Nothing further on the board's business for today. Is there a motion to adjourn? Mr. Quinn, there's a second?
Second.
Okay. King seconds, all in favor, aye?
Hi.
Aye. Opposed, none opposed, we're adjourned.